case briefs, and so much more. LSData's got what you're looking for.
A legal drama unfolded on the icy slopes of the Seven Springs ski resort back in 1983. The central figure was Peter Smith, an experienced skier who took a hard tumble while navigating the perilous North Face. Smith's unfortunate mishap led him to sue the resort, leveling charges of negligence and attributing his injuries to what he described as a breach of duty by the Pennsylvania resort. The plot thickened as Seven Springs counter-argued that Smith knowingly assumed the risk tied to the daunting slope. The resort called upon the Pennsylvania Skiers Responsibility Act in its defense, which upholds a skier's voluntary assumption of risk and can thus offer a legal shield against allegations of negligence. The district court was swayed by the resort's defense, concluding that Smith, cognizant of the risks tied to the North Face and with safer alternatives at his disposal, willingly chose to ski down the tricky route. Therefore, it decreed that Seven Springs was under no obligation to extend protection or assume responsibility for Smith's fall, rendering a summary judgment in favor of the resort. However, Smith was not conceding defeat. He boldly appealed the decision, contesting the district court's interpretation of Pennsylvania law and implying a case of overlooked material facts. His appeal, a twist in our tale, took the case to the United States Court of Appeals for the Third Circuit. The Third Circuit Court weighed in on the matter, meticulously dissecting the nuances of the Skiers Responsibility Act and the applicable legal defenses. The verdict was clear. Smith's assumption of risk substantiated the resort's position. The judges validated the district court's interpretation of the law. Not only did the act preserve the concept of voluntary assumption of risk for downhill skiing accidents, but it also gave rise to two types of defenses rooted in the perceived reasonableness of the plaintiff's conduct. In a true climax, the appeal court affirmed the district court's judgment, maintaining that Peter Smith assumed responsibility for his injuries due to his conscious decision to ski down North Face. It upheld that the resort had no duty of care towards Smith, painting a clear win for Seven Springs. Smith's valiant fight ultimately underscored the power of a skier's responsibility in Pennsylvania, a vivid tableau of assumption of risk and comparative negligence.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.